The death of DeQuell was completely and wholly preventable. DeQuell was just 3 days shy of his 7th birthday when he died.
Justice was late for DeQuell Collins. 3 days late. That's how close he came to his 7th birthday before a bullet took it from him. And when his mother stood in a Milwaukee courtroom to answer for it, the judge didn't just hand down a sentence. She read the room, read the texts, and read the truth nobody wanted to say out loud. This is State of Wisconsin versus DeQuell Collins, case number 25 CF 634.
Going on the record, State of Wisconsin versus DeQuell Collins, case 25 CF 1634. Appearances.
Matthew Tarbinson appears for the state. Good afternoon, Your Honor.
Attorney Abigail Ruckdash on behalf of Ms. DeQuell Collins. She appears in person. Good afternoon.
Cell phones, please.
All right, she's in person. Good afternoon, Ms. Collins. We are here for a sentencing following guilty pleas to 2 counts. 1, neglecting a child where the consequence is bodily harm as a party to a crime. That's a Class H felony. And count 2, straw purchase of a firearm, a Class G felony.
Officer, where does she work? Boy, she works. Huh, that's it. She works. No address, no phone number. The boy doesn't even know his mother's real name. When they ask, he just says, Mommy. He's 6. It's past 11 at night in Miami, and this child is crossing busy streets, trying to open car doors. A homeless man sees it happen and knows something is terribly wrong.
On April 1st of 2025, Ms. Collins' 6-year-old son, DeQuell, accessed a firearm. He possessed that firearm and used that firearm, ultimately resulting in a gunshot wound to his head. Just after 9:30 in the evening, Ms. Collins' mother, Alicia Collins, discovered DeQuell with a gunshot wound to the head. She immediately phoned 911. Emergency responders arrived on scene within minutes and attempted life-saving measures on DeQuell's body. Those life-saving measures proved unsuccessful, and DeQuell was pronounced deceased on scene.
Just after 9:30 at night, DeQuell's grandmother finds him with a gunshot wound to the head. She calls 911. Paramedics arrive within minutes. They try everything they can. It isn't enough. DeQuell is pronounced dead on the scene he was found in 3 days before his 7th birthday. The prosecutor doesn't raise his voice when he says the next part. He doesn't need to. This was completely and wholly preventable. He says, and lets that sentence sit in the room like a stone dropped in still water.
The death of DeQuell was completely and wholly preventable. We have a problem in Milwaukee County with firearms. We have a problem in Milwaukee County with felons possessing firearms. We have a problem in Milwaukee County with individuals like Ms. Collins purchasing firearms and giving those firearms or allowing felons to use those firearms. An argument can
Here's
be
where the
made.
story stops being about a tragic accident and starts being about a pattern. Because a month before DeQuell died, his uncle, DeQuella's brother, had just walked out of custody on extended supervision, a convicted felon, not supposed to be within reach of a firearm, let alone living under the same roof as a 6-year-old who worshipped him, and DeQuella knew. The prosecutor pulls up her phone records. Weeks of text messages between her and her brother, not messages about keeping him away from guns, messages about getting him one, about access, about logistics. At one point, she even asks him to help her buy ammunition for her own weapon, the one that would end up in her son's hands. Pause on that for a second, because the courtroom does. Then comes the video. Late morning, April 1st, just after 11 a.m., DeQuella's brother posts a video on Instagram. He's rapping, holding 2 firearms, his and hers. And in the background of that video, barely visible, are a pair of small feet and legs draped over the back of a couch. DeQuell, in the room.
But when one examines Ms. Collins' text messages in her phone in the month leading up to what happened, it demonstrates that Ms. Collins, with her brother, was acting in concert to get him a gun, to allow him to possess a gun, to allow him to make arrangements to sell her firearm to others in the community. All in an attempt to avoid the consequences. Quintel Collins was a convicted felon. He had just been released on extended supervision for his felony fleeing offense approximately a month or so before this took place. Ms. Collins knew her brother was a convicted felon. She knew he was not to possess a firearm, and she facilitated him getting a gun. She actually asked him to assist her in purchasing ammunition for her own firearm. The two
In your first interview with the detective, just hours after the murder when you had no lawyer, you never mentioned the defendant touching the sword at all, correct?
When she received that video on April 1st of 2025, she sent a text message back to Quintel telling him to put her gun up. Ms. Collins also, according to what she told law enforcement, called her mother and asked her mother to address the situation. She had a video demonstrating the danger right before her. She sent a text message to someone who's completely unreliable and sent a laughing emoji back to her, and then sends a message to her mother saying, "Can you also take care of this situation?" And then
It is a head-on collision of testimonies. One of them is telling the truth and one of them is protecting a massive secret. If Nolan told the girl he was leaving with the boys, and the boys told everyone Nolan was staying with the girl, then who actually decided that Nolan Wells was going to be left behind on that beach? To make matters worse, a video started circulating wild across the internet, a grainy, distant video from the island where you can hear aggressive shouting, a heated altercation breaking out near the shoreline. People immediately
As far as character of the defendant, Miss Collins, at the time that this happened, was working a job. She was working at a group home. When she received that message from Mr. Quintel Collins, she was at that job. She did respond to Mr. Quintel Collins when she saw the video and said, you know, something along the lines of, like, don't do that in front of my son. And then he, in his immature ways, sends back a laughing face. Now, should Miss Collins have followed up? Of course. Now, Miss Collins did talk to her mother, Miss Alicia Collins, who is the owner of the house where Miss Collins, her kids, and Quintel Collins were living. I don't know if that message ever made it to Quintel Collins or if it was too late or what happened with that. The issue that I have here, Your Honor, is sometimes we get caught in our own world here where we think people can leave their jobs whenever they want, run home, do that. Miss Collins wasn't working a job where she could just leave whenever she wanted. She was working at a group home with elderly people, and if she would have just left, those elderly people would have been left alone. That's not something that her job allowed her to do. It's not like she was out in the club. It's not like she was out at a bar and just decided not to come home. She was working a job to provide for her kids.
It is completely unacceptable. And that brings us to the core issue that has set this entire community on fire. The family has hired prominent civil rights attorney Ben
They
Crump.
can't have someone who's charged with a felony working at that group home. I think that makes sense whether or not we agree with it. Ms. Collins then took it upon herself and has been working at Amazon since then. She works 4/12s, so she works 4 on, 3 off. And on her off days is when she schedules and
Video end
takes
time, Olive Fancy in 3/8 now. Annie Rivera is arrested around noon, roughly 12 hours after her son was found. And here's where her story begins to unravel. According to court records, she told investigators she finished a job at a studio in Miami that evening, took a ride, share home with her son around 8:30 p.m., put into bed. Then just after 1100, she left again to meet a friend, grab food, then go work another studio inside a club. She got home between 3 and 4 in the morning, while her 6-year-old was out in the streets. The living situation is...
And takes her children, her 2 remaining children, to therapy. One is 4, one is 2. Obviously, it's a little bit hard for children that little to sort of process what they've gone through and things of that nature. So I am really proud of Miss Collins for taking her kids to therapy, no matter how little they are. I believe they go to what's called shoreline therapy. They have offices in Wisconsin, Illinois, and Colorado. The two kids do their therapy together, because I'm told, I don't know if it stems from this incident or what, or if it's a trauma response, but the two children cannot be separated from each other. The 4-year-old and the 2-year-old have to be together all the time. They only have two people that they feel safe with, Miss DeQuayla Collins and Miss Alicia Collins. If they try to go with other friends and family members, they cry.
That's the moment the story asks you to feel something other than anger. A 4-year-old and a 2-year-old who don't understand why their brother isn't coming back, who can't be pulled apart from each other because the ground already moved once under their feet. But sympathy has a ceiling in this courtroom, and the judge finds it fast. She starts asking questions herself. Where was DeQuayla when she got that video? At work, the defense says. No, actually, the timeline gets murky here, and the judge notices immediately.
So she was at work at 9:30 that night. What time did she start work?
What time did you start work that day?
I got there at 7.
7 p.m.?
Yeah, I did first and second shift.
She got there at 7 p.m. that day, Judge.
7 a.m.
Oh, 7 a.m. So were you working?
I did
You're
first
14 and a half
second
hours.
shift.
Oh, she worked a double that day.
I worked first and second shift.
That's what you were saying. I
The
misunderstood.
criminal complaint speaks of you being at your boyfriend's house when you got the email. Or
That was the day
got the
before.
video.
That was the day before on the 31st. She was at her boyfriend's house. She was at work on the 1st.
Okay. The video was sent the day before?
No, the video, I believe, is sent that day.
She saw it when she was on break from work. She went to her boyfriend's house on the 31st and went to work that morning of the 1st.
I'll pull up her statement, Your Honor.
Please do.
There's a difference between looking guilty and being guilty. You have to be guilty beyond a reasonable.
Judge, I apologize for interrupting, but just to provide some further context, on page 33 of the police reports in the defendant's interview, she admits that she was at her boyfriend's house when she received the Instagram message at 11:28 in the morning, not at work. She also doesn't send or call her mother until 3 o'clock in the afternoon because her mother worked a double that day. It was her mother that worked a double, and her mother didn't get off of work until 3 p.m. So the first contact she had with anyone else in that residence, other than sending the single text message back to her brother, was her mother at 3 p.m.
If he was the mastermind, why would he call the police on himself? Why would you wash off evidence? I don't know. Maybe he panicked. I was in shock. I can't explain his mind. You see ghosts of the victim and the defendant.
Police report says
Ms.
it
Collins
her
tells me
own
that's not
statement.
true, so,
But that's what she said. Do you agree that that's what she said in her statement?
yes,
And now she says it's not true?
correct.
Okay.
They have proof of me being at work.
Regardless,
You said you felt his energy in the jail, even when he wasn't there. You have an alter ego that comes out when you're drunk.
and Ms. Ruckdaschel is absolutely right. You should be able to trust your family to protect your children. But when they send you absolute billboards full of information that says, I'm not protecting your child, you have to act. And this is...
You've admitted you have a crazy side, all of this, and you want this jury to believe your memory of what the defendant did is reliable. I'm not crazy, I miss her. I see her face everywhere. I can't escape it, I loved her. The camera cuts to a small, worn photo on the prosecutor's table. The victim, age 19, smiling with braces, a school photo. The defendant's mother wipes her eyes.
In retrospect, I think your concern was for your son. And I acknowledge the pain you must be going through must be unfathomable. But you're tattling like a sister does. He keeps touching my stuff.
It isn't
Judge, just a-
cruelty. It's precision. The judge takes every text message, the ones about splitting profit on a resold gun, the ones about getting a clip back, the ones about her son, steady talking about it, and lines them up next to the one moment DiCruella claims she was protecting her child. And the math doesn't work. Not one message asks anyone to get her son somewhere safe. Every message is about property, her property. The judge doesn't raise her voice for the next part either. She doesn't need to. We've lost all of the wonderfulness that could have been him, she says. He could have grown up to be anything.
We've lost all of the wonderfulness that could have been him. He could have grown up to be anything. He could have grown up to be a really hard worker like you and his grandma. He could have grown up to realize that breaking the law is not the way to go. And he was denied that.
Then she turns to the actual decision. Probation was on the table. The defense asked for it, argued DiCruella had already lost more than any sentence could take from her, argued that losing a child is its own life sentence. The judge doesn't dismiss that pain. She acknowledges it's unbearable, but she comes back to the law, plainly.
And the law does not carve out something that says, well, you can live in a house with a gun if you're a felon because it's your blood, because you didn't have anywhere else to go. I understand it can make things certainly very uncomfortable for people. He'd just gotten out, he didn't have a plan, whatever. The fact is, though, that's not the law.
The law does not carve out an exception because it's your blood, she says. Felons can't have guns. You knew that. And you were all in. No probation. She sentences DiCruella to 6 years on the neglect charge, 3 years of initial confinement, 3 years of extended supervision, running concurrent with 6 years on the straw purchase charge, same structure. The bottom line, 3 years behind bars, with 17 days of credit already applied.
I will sentence you to 6 years on count 1 in the Wisconsin State Prison, 3 years initial confinement, 3 years extended supervision. That will be concurrent to count 2. On count 2, I will sentence you to 6 years in the Wisconsin State Prison, 3 years initial confinement, 3 years extended supervision. I know I just said a bunch of numbers. That means 3 years in. That's the bottom line number for you right now. And that's 17 days credit will apply to both because of the way I've structured the sentence. I wish you well.
A full mental health evaluation is ordered, not as a diagnosis, the judge clarifies, but because there's no version of processing this that doesn't require real help. No contact order with the person still facing charges in DiCruella's death. But notably, no contact order against her brother. The judge says flatly she doesn't know how that relationship comes back from this. But it isn't her place to decide it never will. And then, the line that closes the hearing harder than any gavel could. Nobody is winning. No one in Milwaukee is winning by just getting more and more firearms.
On this, I'm going to run these counts concurrent to one another. There were decisions made at different points that led up to this, but I believe it was all part of twisted sense of